Thank you all for joining us today. It's good to see that there are a number of people attending. My name is Dustin Saldarriaga. I am a senior associate at Scott Legal PC. And today we're going to be talking about one of the most popular options for our clients to come to the US to develop and direct a business, which is the E-2 Treaty Investor Visa. And we'll specifically be talking about E-2 visa applications with a low investment amount or that are otherwise risky. And when we say risky, we mean that they face a high risk of denial. But as we'll discuss in this webinar, there are certainly ways to mitigate those risks. Definitely some strategies that we employ and that we look forward to sharing with you. And I should say that our firm has actually developed a kind of expertise in helping our clients navigate through these more risky scenarios. Our firm's experience is really based on the experience of our founder, Ian Scott, who is currently on an E-2 visa and actually founded our firm on an E-2 visa. So his experience personally navigating the process by forming a service business that had a low required investment really did form the groundwork for how we over the years have worked with a number of clients to also navigate the process. We're very fortunate to have my colleague Jiyae Hwang, who is also a senior associate, who will be speaking about the E-2 visas. Jiyae has also developed extensive experience preparing these applications, so it'll be great to hear from her. Before we get started, there are a few things I wanted to run through. First, as this webinar is part of a series, we try to do at least 2 webinars a month, and we cover a variety of immigration topics. So although our firm does focus on business immigration, we do handle family immigration cases, we handle humanitarian cases, and we also handle litigation in case we must sue the federal government on an immigration case. We do handle those cases as well. So regardless of what your immigration issue is, please do reach out to us if we can be helpful. After this presentation, we'll send you the PowerPoint, which you see on your screen now. We'll send you a comprehensive guide to the E-2 visa, as well as a link where you can sign up for those future webinars that I mentioned. This webinar is being recorded, and we post our webinars to our YouTube channel, along with a variety of other webinars, as well as shorter videos. And again, those do cover a variety of topics, and we're very proud to put out good, high-quality videos on a variety of topics for free. So do check that out. That link will be in the email you'll get after this webinar. If you have any questions, then please do send them to us through either the chat function on Zoom or the Q&A box on Zoom. And we will be monitoring those, and we'll either answer the questions in the moment they're asked, if they're relevant to where we are in the presentation, or we'll answer those at the end. But either way, we do plan to get to all of the questions that are asked. So without further ado, I will pass it off to my colleague Jiyae to talk about the E-2 visa requirements.
All right, thank you so much, Dustin. So let's get started here. The E-2 visa requirements explained. So it is worth noting at the outset that the E-2 visa is a non-immigrant visa, and it is really for investors who are seeking to come to the US to develop and direct a US company that they invested in. And as we will go over, this company can be of a variety of types, and it can be a small business as well. Now, the E-2 visa won't necessarily directly lead to a green card, permanent residency in the US, but the applicant can continue extending the E-2 visa indefinitely as long as the applicant continues to meet the E-2 requirements. So what are those requirements? Let's go over them one by one. So you must be a national of a treaty country. So a treaty country means one of the countries that have signed an economic relationship treaty with the United States, and you can find a list of these treaties on the Department of State website. And they are updated from time to time, so it is not really a static list, but you can certainly go and do a Google search and find the list there. And the applicant must own 50% or more of the treaty enterprise, which means the business that they are starting up in the United States. Now, the investment. So the applicant must make a capital investment, and this investment must be funds put at risk, and the amount of this investment must be substantial. And this really means a lot of the money has to actually been spent towards preparing the business before you actually apply for the visa. So you cannot qualify for the visa based on speculative plans to invest in the future. You must already have made the investment by the time you apply. Now, what is a substantial investment? There is no hard minimum required by the law. However, USCIS and the consulate will look at if you have put in a substantial amount in terms of making all of the expenditures that is necessary to get the business to a point where it is ready to hit the ground running. Now, let's talk a little bit about source of funds. The applicant also needs to prove that the investment capital has been sourced from legitimate sources. So, for example, saved earnings from employment, a gift, or a loan that you got from a bank, or a relative or a friend. That can also work. Private loans can work. In the case of private loans, however, you would also need to show where the gifter or the loaner got the money from. So there is another source of funds inquiry there. If you get a loan from a bank, you don't need to go through that additional step. However, in terms of loans, you do need to make sure that the loan is not secured by any of the assets of the E-2 business itself or secured against the E-2 business. Now, let's talk a little bit about marginality. Now, marginality refers to the revenue generation potential of the U.S. business. So the E-2 business that the investor will set up in the United States cannot really be a one-person shop, right? So this means the profitability of the business must be enough such that the profits and the revenues from the business will not only just support the investor and his or her family, but also will allow the U.S. business to hire U.S. workers. And our recommendation is that the E-2 investor plan to hire at least 3 to 4 full-time employees within the next 5 years of the E-2 business being operated to meet this marginality requirement. Now then, let's talk about the real and operating requirement. This means that the E-2 business must be ready to start running once the visa is granted, or the business can be already taking revenue if possible. So this means the entity in the U.S. must already been established. If it is a business that requires an office, the business lease must already have been secured. Any required licenses for operating in that industry must have already been secured. And it is very favorable if you already have client contracts or letters of intent showing that there is existing demand that for the services that the business will provide, services or products, once you are granted the visa. Now, another requirement that you must satisfy here is that the investor, the E-2 applicant himself or herself, must be coming to the United States solely to develop and direct the business. This means if you're granted the E-2 visa, you must only work in your E-2 business. You cannot be an employee of another entity in the United States or work for other businesses in terms of being an employee of any other business other than the E-2 enterprise that you are setting up and running. And this also means the direct and develop also means that you will be acting as a manager of the business and not necessarily being, the frontline employee that actually provides services or actually does all of the operational aspects of running the business. You will be expected to hire employees in the United States to actually perform such labor, such that your primary role will be managerial, executive, such that you are leading the management of the business. Now, the last requirement is that you need to show that you have an intent to return to your home country upon the expiration of the E-2 visa, and this is because the E-2 visa is a non-immigrant visa. And usually, though, for the E-2 context, this can really be easily satisfied by providing a signed declaration of the E-2 investor's intent to do so. So this is usually not too big of a problem unless if there are some particular circumstances, such as if the investor has applied for a green card in the past or has one pending, that could be a consideration here. All right, so now let's move on to the next topic, the E-2 visa requirements. We can go into a little bit more detail on who can apply and how long an E-2 visa would be valid for. So as noted before, the E-2 visa is a non-immigrant visa that allows nationals of certain countries to come to the US to develop and direct the operations of an enterprise in the US in which they have invested money. And you can also get the E-2 visa either through setting up a new startup, or you can also purchase an existing business and have that be the basis of your eligibility for the E-2 visa. Now, you must be a national of a treaty country, as I mentioned before, and you can find the list of treaty countries here by Googling Treaty Countries Department of State, and you will see the comprehensive list of participating countries in the E-2 program. And this really includes numerous countries, including countries in Europe, Africa, Asia, Latin America, Middle East. And just some examples are the UK, Mexico, Canada, Chile, Philippines. And the list is updated from time to time. So Israel was actually added relatively recently for the E-2. As for notable exceptions in this list, China and India and Russia are 3 countries that do not participate. And this is just an example. So the first threshold inquiry that any potential E-2 applicant must do is to see if they have a nationality in one of the treaty countries. Now, it is important to note here, though, that national means having a passport in that country. It does not depend on the applicant's country of birth, as opposed to the case of green cards, for example. So if you are a dual national of India and Canada, for example, you could certainly qualify for the E-2 visa based on your Canadian passport. So that is something that I wish to note here. All right, so how long does an E-2 visa last for? So the answer here is that it depends on your country of nationality. And you can look at what the exact time period is by searching Reciprocity Schedule, Department of State in Google. And for many countries, the E-2 visa is valid for up to 5 years. Now, however, in particular cases, the validity of the visa itself can be as short as 3 months. So it is very important to check what the rules are for your particular nationality. And in discussing this, I think it would be very important to note that the length of the validity of the E-2 visa is different from the length of E-2 status that you get, which is 2 years for each entry, right? So the visa validity time, the validity period of the visa stamp itself, is the amount of time you're given to make the travel to the United States, right? And this is different from the length of E-2 status authorization that you are given once you ask for entry into the US, and you get an I-94, which specifies the period, how long you're allowed to stay within the US in that particular entry. So this is for 2 years. So let's say you have an E-2 visa that is only valid for 3 months. If you travel to the US within that validity period and gain admission as an E-2 investor, you will be given 2 years in which you can stay in the US and have the time to develop and direct your business. And you can always check this on your I-94 record. This also means that even if you have a 5-year visa, right, when you actually enter the United States, it doesn't mean you can stay for the whole 5 years. You need to check your I-94, which will, usually be valid for 2 years, right? And within the 2 years, you either need to go out and go in again, or extend your status, because the I-94 record controls how long you are allowed to stay for that particular entry. All right, so let's move on to the next topic. How much investment is enough to qualify for the E-2 visa? And I believe that will probably one of the topics that most of you are interested in today. So it is important to note here that there is really no minimum in regulations or law, so there is no hard number for how much investment is needed. However, the amount does need to be substantial. Now, what amount is substantial? This will really depend on the type of business that is being started. Now, let's talk about startup companies. The case of when you are starting up a new business in the United States to qualify for the E-2 visa. So let's say you are starting up an office type consulting business, right? Service business. So really the assets you are offering is your intellectual services. So those kinds of businesses, office-based consulting types, would require a lower amount than other types. So let's say an $80,000 investment to set up the whole business, right? Because and this is the reason why is because there are not that many typical upfront costs to start such a business. So you would have a business lease for office space to meet clients and collaborate with employees. You would typically get computer equipment to use in your business. You may also invest in some furniture for the office. You may also invest in business insurance if you need it. So those kinds of upfront costs, and maybe you will invest in a website to attract clients. Maybe you will invest in going to some business development events. You may pay some registration fees, so things like that. Those are the kinds of startup expenses you could imagine. However, let's compare this with the case of a different type of business, such as a restaurant or a manufacturing company or a retail store. Now, those kinds of companies would typically require a higher amount of investment to qualify as a substantial investment, right? And the reason why this is the case is because typically more expensive equipment, machinery would be required, as well as a larger space typically to warehouse the inventory, et cetera. So really, you can see that the type of business is quite important in determining how much investment amount is sufficient. Now, what is the proportionality test then? So the proportionality test really means that the smaller the total costs required to set up the business or purchase a business, the higher proportion of these costs the government would expect that you would have already spent. So for example, let's say going back to the example of the small consulting company with upfront capital of $80K investment needed to fully start up the business and have it ready to go. In a smaller business like that, a smaller type business like that, the government would expect that the applicant would have already spent 100% of all of what's needed to start up the business. And I'm comparing this to a different kind of business that require higher upfront costs, such as, 100 million business manufacturing large-scale solar panels, for example. In a business like that, you could have simply invested maybe 10% of that, and that'll still be 10 million. And the government will still think that is a substantial investment, given the volume of the business is substantially higher. Now, let's talk a little bit about buying a business. So as I mentioned before, there are two ways you can qualify for the E-2 visa, one of which is starting up your own business from scratch. And the other option is to buy an existing business in the United States. Now, what investment is substantial will depend on what is the fair market value of the business that you bought. So if you bought the business in the open market, right, you likely paid the fair market value for that business, and that would usually be considered a substantial investment. Another consideration that is important in determining what amount is substantial to qualify for the E-2 visa is which consulate are you applying to? Because different consulates around the world have different standards on what they see as substantial investment. So some consulates in the world, such as Japan, for example, would consider any investment below $100,000 total as insufficient to qualify for the E-2 visa. While by contrast, other consulates may consider investments as low as a little bit over 50,000 even, that could be sufficient given the circumstances. Now, that is certainly, though, a riskier case, so that is why we will be talking about how to offset such lower investment amounts and increase the increase the possibility of approval for those kinds of cases and make it stronger. But this is just to make note that where you apply is also a very important consideration, and it is so important to work with a law firm that actually do understand those nuances. All right, so the next slide, strategies to deal with a low dollar amount, right? So as I mentioned before, if you are preparing a case where the investment is lower, on the lower side, there are several strategies you can use to strengthen the overall merits of your application to minimize the risk of denial. So what I would do is, first of all, ask what is the overall strength of the E-2 application as a whole. If the other aspects of your cases are strong, for example, for marginality, profit generation potential, hiring of employees, evidence of client and interest, such as evidence by letters of intent from potential clients, contract with potential clients. If those aspects of the cases are strong, then you could be okay with a lower investment amount. Now, one strategy is really to strengthen the real and operating aspect of your E-2 case. So really make sure to prove that your company is ready to go, hit the ground running. And you can do this by obtaining letters of intent from clients that show an intent and willingness to retain the company's services once the company is fully launched and up and running. You can also secure contracts or purchase orders for products in advance of you applying for the E-2 visa. And you can also reach out to local commerce organizations such as Chamber of Commerce. That can also be another way to support that there is demand for this type of business and that you have spent everything that is necessary to get that type of business up and running. So a letter from the Chamber of Commerce could help with that. Another very advantageous way you can strengthen your application is to go ahead and hire a U.S. employee. And hiring a U.S. employee could also be good because it also boosts your investment amount. Any salary that you spend on a U.S. employee, even if it's, administrative assistant or a part-time employee, all of these costs can be added to your investment schedule, and this can boost the amount spent in terms of strengthening your application. And again, if the business has already been generating revenue, either through these existing employees, then that can also help support your case and strengthen the case, even if the initial investment is on the lower side. Another strategy you can use is really make sure to have a strong business plan, showing the strong profit generation potential of your particular niche and your particular services that can be a persuasive factor on showing the merits of your case. And again, if you can, hiring U.S. employees is a great idea. It is not required for approval of the E-2 visa, but it can certainly strengthen the case. So let's talk a bit about case studies. Let's look at two different examples. Let's go back to where we were. Okay. So on the first example, let's say you are opening a business and the investment amount is low. Let's say you invested $60,000 in total. However, you already hired 2 U.S. employees and the business has already started taking revenue. And this is possible because you already hired the employees, right? And let's say that the revenues are quite high, around 80K in revenues per month. And you already have around 10 clients, and you can show that you have these clients by showing copies of purchase orders or contracts, evidencing that there is already a flow of commerce. Right. So in example 1, then, this can be categorized as a very strong case. Even if the investment amount is low, the business is obviously already operating and the business has high profit generation potential. And the investor has already proven the ability to hire multiple U.S. employees. So in that case, we can certainly be confident that this will be a strong E-2 case for approval. Now let's look at another example. Let's say you are applying for an E-2 visa and the investment amount is low. Let's say you invested only 50K total. Let's say you don't want to invest any more money. You don't want to hire anyone until after E-2 visa is approved and you come to the US. And let's also say you were unable to get any evidence of client intent to hire the business's services, either through a letter of intent or a contract or a letter of support from the Chamber of Commerce. Let's say you have none of that. Then it is possible that the government will look at this and say, I'm really not sure if everything that is necessary to set up this business up and running has already been spent, right? So in that case, because the other aspects of the E-2 requirements are also a little weak in terms of, real and operating, marginality, this could really be a riskier case in terms of, possibility of denial. All right. So now then, let's go a little bit deeper into what kinds of expenditures in terms of investment is common for businesses, investors who are applying for an E-2 visa. What are some areas that are strong, and what are some areas that are not as strong in terms of constituting what counts as investment, what counts as the expenditures? Now, you can think about, you can also ask yourself the question, what are some of the legitimate investments that you would need to set up a business in reality? So for example, business office space that is usually required for a business equipment, if that is related to what the services or products that you are offering, if necessary, to produce them. So in terms of, intellectual type businesses, such as consulting, computer equipment is very common, right? Because usually you would rely on those tools to produce such work product. Marketing or advertising, that is also a very common area of investment that we see. When you are setting up a new business in particular, you would want to build a profile either online or otherwise to really make sure that the client base knows that your business is there, and make sure that you are attracting a stream of potential revenues. Any licensing fees. So it is very important to research whether your particular business area requires a license to operate. And I do know that in many jurisdictions, if you're operating in real estate brokerage or things like that, you may require a license to do so. So all of these, the fees related to you securing that license is also an excellent form of investment. Any administrative costs that you incur to set up employee payroll, for example, and also any salaries that you spend on employees, that can also be included as a very good example of expenditures for your business. To the extent you are using accounting services related to that, you can also add those costs as part of your investment. With respect to equipment, as I mentioned before, common equipment that we see include computer, printer, scanners, office supplies, office furniture, such as desks and chairs, as long as they are reasonably related to your business. Now let's talk a little bit about what are some good versus bad expenditures. Right. So strong expenditures are basically what I just mentioned before on the previous slide. And I can just go back to the previous slide to discuss strong expenditures. As I mentioned before, marketing expenses, a commercial lease, computer equipment, and if it's a retail type of business, any purchase of inventory, that can also be a legitimate way of showing investment. Purchases of IP, intellectual property, trademarks, if that is related to your offerings. Legal fees used to set up the business can also be included. Any costs incurred in relation to business entity setup. So if you are setting up an LLC or a corporation, and if you incur filing fees for that, you can also add those. Those are very good expenditures. And licensing fees, as I mentioned before, can be a strong example of strong expenditures. By contrast, travels, flights. So we sometimes get questions by clients who say, oh, okay, I flew to the United States several times to speak with potential business associates, network, and do things like that. And, the thousands of dollars that I spent on the flights, can I include those as a part of my E2 investment? And usually we do not recommend adding those costs. In a similar vein, any hotel accommodation costs, any transportation such as Ubers, taxis, going to and from your location to wherever you're meeting clients, those are really considered more like business expenses, and not very strong in terms of being considered as investment for setting up your E2 business. In a similar vein, meals and entertainment, even if they are incurred in context of business development and client meetings, we counsel clients not to include those costs. Similarly, expenses, if you're pre-booking something on behalf of a client and you will later be reimbursed by the client, those things are also not strong in terms of being considered the qualifying E2 investment. Another risk factor is if you are paying any expenses to related parties. Related parties, let's say your brother is a website designer and you pay like 10K in website design to your brother. Now, not the most recommended fact pattern there, and really it is because because it is not a service that you paid through the open market. There is a little bit of subjectivity there and less objectivity in that transaction, so there is a little bit of more risk there. Similarly, transactions between business partners who are both participating in the E2 investment, that may not be that may be a little bit more risky form of expenditures. All right, so I think that's it for my presentation part. Now we do have a lot of questions that came in. Dustin, what do you think?
Yeah, so Jiyae, there were a few that touch on expenditures. So I think there's a nice segue there. So the first is, could an RV for a mobile office wrapped in advertising be included as a good expenditure if it's for a social media agency?
An RV for a mobile office wrapped in advertising.
Yeah, so I think this is getting to, whether you can count a vehicle as an E2 business expense. And I think the way to think about a vehicle is the government is going to start from a skeptical standpoint. So assume the government's going to be skeptical of a vehicle being necessary for the business. So what you want to do if you're going to include the vehicle is make it very clear that it is only for the use of the business. In other words, it's not also for your personal use, and B, that it is necessary for the business. So in what you've described here, if advertising for a social media company is, requires the use of a vehicle and you can show how that really is an important part of the company's marketing plan, then yeah, I think that this could be used as a viable expense. But do keep in mind the government will be skeptical, and also you don't want the relative cost of the vehicle to be enormous compared to your overall investment in the business. So if you have $100,000 to invest in the business, don't spend $60,000 on a vehicle. Maybe spend $20,000 and have an additional $80,000 on other things that the business needs. So Jiyae, on the topic of expenditures, this was another great question. How old can the expenditure be? So this participant started investing prior to COVID, but the application was put on pause. So can those expenditures be used?
Yeah, so there is no time limit on how old an expenditure can be. And obviously, yes, put it through the reasonability test, right? So and I do think that it also depends on what you're claiming for. So if let's say you bought a laptop and you will be using the laptop for your business, you could potentially claim it even if it's a couple of years old, right? As long as you can make that link clear. So yeah, it really depends on what the spending is for, and whether it can be directly tied to the operations of the business. But provided you can do that, there is really no hard limit on how recent the expenditures must be. But please do note, though, that the source of funds would still need to be accounted for. So you want to make sure that you do have records of what sources, where you got the money to invest in for that particular expenditure.
Perfect. And then is social media advertising included for expenditures?
Yes, it is a common expenditure that we see. So for example, if you purchase Facebook ads or Instagram ads after you set up your business to advertise for your business, that can certainly be included as marketing fees for the E-2 purposes.
Perfect. All right, and we'll save there. There are a number of other questions. We'll save them. I'll address some in my presentation, and then we can save the rest for the end if that sounds good to you, Jiyae. All right. So if you don't mind going to the next slide.
Yeah.
So some common challenges and tips for consulting businesses. So basically, over the next 3 slides, I'm going to be applying some of the things that Jiyae talked about, specifically what the E-2 requirements are and how to use those requirements to address a relatively risky case. So the first kind of applied situation is a consulting business. And a consulting business is typically risky just because it doesn't need a lot of money to get started. So as an example, consulting businesses and law firms, you can put them in the same category because of the low startup costs. So our firm, to get a law firm started, all you really need is a small office, a computer, maybe a subscription or two to some legal resources, malpractice insurance, and with that, you can start operating. You have everything you need to start operating, and that might cost you no more than $20,000 or so. So the same is true for consulting businesses. So given that, how should you approach an E-2 application for a law firm or a consulting business? I think it's important to keep in mind that there are 2 reasons for the investment requirement, where Jiyae said the requirement is a substantial investment. So there's no set dollar amount, but what the government's looking for is 2 things. The first is the government wants to see that you have invested enough money to show that you're committed to the business. And it's a very simplistic thing, and it doesn't necessarily make business sense. Usually it makes more business sense to pay nothing and get the business going and reinvest revenue and then grow the business that way. That's not how the government thinks about it. It wants to see, okay, you've put a significant amount of your personal money on the line. Therefore, if I give you this visa, you're going to actually start this business. The second thing they're looking for in the investment amount is that you've bought all the things that the business needs to be operational. So let's look at how those play out in a low-cost business, like a consulting business. So basically, the first thing you want to make sure you've done is bought everything that the business needs. So that's essential. You can't leave anything left out. You need to show you have an office space. You need to show you have the computer, the office furniture, you have all the licenses you need. So let's say you've done that and you really are at a low investment amount. And by that, under 50,000, I would probably put in that category. You should start at that point thinking about how you can increase the expenditures that you've already made, or think about additional expenditures that aren't necessary but might benefit the business. So for example, we've talked about marketing through a couple of the questions. Marketing is oftentimes something that you can put more money toward, and it does benefit the business. So buying more Facebook ads, buying more Google ads, buying printed materials, paying for a better website, a more interactive website, and maybe paying for an independent contractor to develop that website. Paying for your office lease in advance. I know that there's a question on that. If you pay a few months in advance on your office lease, that can certainly be done, and that can significantly bolster your investment amount. If you pay for 6 months of the office lease in advance, or even a year in advance, you can include that as a startup expense in your investment schedule. So that's something to think of is how can I bolster my expenses? Well, not just throwing money away, but actually thinking about things that will be useful for the business. The second thing, once you've done that, if you still are at a relatively low investment amount, what you want to think about is how to strengthen other aspects of the application. And GA also talked about this. And the thing to really keep in mind when you're thinking about how to strengthen other aspects of the application is to imagine how the consular officer or USCIS thinks about the application. And the thing to know is that the most important thing that an officer is looking for is to be convinced that the business will employ US workers. So if the government officer is skeptical that this is a business that will eventually employ US workers, they're probably not going to approve the application. And that's the first concern they would have about a low investment amount is there's just not a lot committed to this business, and I'm just not sure it's going to employ people. So what can you do? You can employ someone. So I used the example before of hiring an independent contractor to work on the website. You can use that independent contractor as proof of employment. And I know that there is also a question, would a US contractor count? The answer is yes, a contractor would count. You're not required to employ W-2, employees. It really is a spectrum. So, ideally, you would show that the business is going to employ at least 3 full-time equivalent US employees over a 5-year period. That is the ideal. It is okay to use part-time workers, and of course, you'd want at least 6 if you're working with part-time, so full-time equivalent. And you can use independent contractors. If, for example, if your business is in a field where full-time employees really aren't common, the industry tends to use independent contractors, that can be okay. But you do want to show that you're providing work for a significant number of independent contractors. It can't be 3, it can't be 5, it needs to be more than that. And you also ideally will want to show that these are long-term relationships. It's not just one contractor for 1 week, another contractor, another, that these are independent contractors who tend to stay with you, tend to come back and get work from you. So that's kind of over a 5-year spectrum, 5-year time frame. The goal is usually at least 3 full-time equivalent US workers within 5 years of starting operations. But if you're at the early stage, which is what we've been talking about here, having even 1 independent contractor before you file the application can be a significant advantage if you have a low investment amount. So think about how you might hire someone. Other roles that people do hire early on can be like an office manager, someone who's based in the US, especially if you're applying from abroad and you want to get the business running in the US. You can have someone on the ground that you're paying as an independent contractor who's really just doing kind of office management, maybe a little bit of marketing, maybe handling customer issues. If you can have them as an employee, even better. But think creatively about that. So we can go to the next slide, Jiyae. So for real estate investments, so we talked about consulting businesses. Real estate investments are also risky, and the reason for that is that the government's assumption when it comes to a real estate business is that the business is speculative. And what that means, what I mean when I say that is that it's really a business that depends on the appreciation of the asset. The government assumes that the business is going to purchase land, basically just wait for the land to appreciate and then sell the land or sell the property. And that will not get approved. And the reason is that you need an active business that both requires you to be an active manager of the business and that requires the employment of US workers. Again, at least 3 full-time equivalent US workers over 5 years. So if you do have a real estate related business, what do you do to strengthen the application. First of all, don't have a holding company, right? It can't be a property holding company for it to appreciate. Simply purchasing property, putting it in an LLC will not qualify for an E-2. You have to show that the business is actually real and operating and is not speculative. So examples of what can work are brokerage firms, property management companies where you have people actually going into properties, cleaning them, renovating them, real estate renovation and construction companies. So where you actually have people building, actually buying materials, constructing things, and house flipping. House flipping can work. But again, you want to show that you need to employ US workers. And so to do that for house flipping, you probably need to do house flipping on a relatively significant scale. So, it can't just be one or two homes. You want to show that you're going to be working on several. And again, the reason is to show you're generating work for US workers. Again, at the end of the day, when you're coming up with your business idea, really you want to show that the business requires you to be an active manager at developing and directing the business, and that you're going to need to employ US workers. So the next category of businesses is equity trading companies. So these are similar to the property investment companies in that the risk is that the government will view them as speculative or passive. So you really do need to show that this is a business that will require you to be an active manager at developing and directing the business, and will require people to be employed at the business. So again, just placing stock in a portfolio within an LLC is not going to be sufficient. You need to show that you actually do have a client list or a significant list of prospective clients that go outside your family and friends, that there is real interest in people being served by your company. Because again, you need to convince the government that this is an active business. And also something to keep in mind is that because these types of businesses are regulated, you do typically need certain licenses to give investment advice and to trade investment vehicles. You want to have those licenses lined up. So, take the course, actually take the test, pass the test, get the license, and show in your application that you have that license. And since we're talking about licenses, one of the common questions that comes up is if you can include that as an E-2 expense. And the answer is that licenses, if they're specific to your business, are typically a fine investment, a fine item to list on your investment schedule. So as an example, if you're starting a restaurant and you get a license from the state's health department and you pay $100 for that license, it's fine to include that $100. However, if the license is more an investment in you as a professional, that's different from an expenditure for the business. If you look at it as a spectrum, on one end you have the restaurant I just mentioned, which got a license to serve food. At the other end is your college tuition. That's clearly an investment in you. If you tried to use your college tuition payments to say, well, but I needed that education in order to trade equities, the government's not going to buy it. It's not an expense for the business. So these licenses that I'm talking about on this page to be able to give investment advice, I would say fall closer to the college tuition end of the spectrum because they're an investment in you rather in your specific business. I probably would not list them. But if you're in a situation where you really cannot increase your expenditures, you might need to include them, in which case have a discussion with your lawyer in that situation or with us, and we can talk through it. So what are common reasons for E-2 denials? The first we've talked about pretty extensively is a low investment amount. Even though there's not a dollar value that the government says is required, the government does want to see you're committed to the business and that you've bought everything that the business needs to get started. One other thing that we do sometimes do is offer supporting documents. So for example, an example I really like to use is I had a client who was starting a tattoo parlor, and they had invested a certain amount. It was relatively low, but it really was everything they needed. So one of the things we did was we got trade publications, tattoo trade publications, where experts in the field talked about how much it cost to start a tattoo parlor, and they had invested significantly more than those publications said was required, and that helped the application. That application was approved. So think creatively about showing that you really have invested what's required for the business. The nature of the business. So I've talked about equity trading companies, real estate companies. Certain businesses are simply riskier. So if you're starting one of those businesses, you need to go in with eyes wide open and ready to address the scrutiny that the government will give. Filing location and venue. Jiyae talked about this. Certain consulates are simply stricter. Certain consulates tend to see larger businesses. So if you apply with a lower amount, it will raise flags. We're not going to go into specific consulate by consulate requirements in this webinar. So if you're interested, if you have a list of maybe 1 or 2 consulates you're eligible for, or you're curious which ones you'd be eligible for and what the investment requirement is, go ahead and schedule a consultation with us. I know a couple of the questions talked about, for a specific consulate. Do schedule a consultation and we can talk about that. One of the other common reasons for an E-2 denial is if you have a similar business abroad that has not employed has not employed employees. And the reason for that being an issue is pretty clear. If the consular officer is most concerned that this is a business that they most want to see that this is a business that will employ U.S. workers, if they know you've tried the same business abroad and they ask you how many employees you employed and you say only 1 over the course of a decade, the government will be skeptical, and you'll need to give them reasons why this time around in the United States it's going to be different and you actually will have employees. So it's something to anticipate if you had a business abroad that didn't employ workers or a significant number. Just go in knowing how you're going to address that weakness in the application and address it proactively. Don't leave it unsaid. Concern over whether the business will create jobs for U.S. workers. That's very much related to the point I just made. If your application raises concerns as to whether you'll employ workers, the best way to address that concern is to hire a worker before you apply. So, I already talked about that, hiring an independent contractor, but that is a good way to address that concern. Issues with the adjudicating officer. In immigration cases, the government has a lot of discretion, so they can deny almost for any reason. And sometimes you just get an officer who's in a bad mood or is not aware of the law. So that happens, and there's usually not much you can do about it. However, you can usually apply again, and many consulates will try to assign your case to a new consular officer if you apply again, which is a good thing. And finally, some applicants simply don't meet the requirements. We have people come to us after having been denied, and we look at their initial application, and it doesn't satisfy the requirements for whatever reason. And that does happen. So it's important to be aware of the requirements and make sure that you address them. All right, trends and hot topics. COVID continues to have an ongoing impact. Consulates, we're very backlogged. They're getting faster. So the delays we were seeing a year ago, 2 years ago, definitely aren't as significant as they were, but you can still expect to wait, I'd say, between 2 and 4 months to get an interview at a consulate for an E-2. So they're not going extremely fast, but we're not seeing the year-long waits at most consulates that we used to see. You can extend your status in the US on an E-2 if it turns out that your consulate is backlogged. It is an option to extend your status in the US through USCIS. And USCIS, one of the big things to know is that they cannot issue a visa. You need to go to a consulate to get a visa. So if you change or extend your status to E-2 status in the US, you cannot travel. in that status. So as soon as you leave, you'll abandon your status. You'll need to get a visa at the consulate, which is why we almost always recommend that you go for a visa at a consulate. All right, some quick questions, and then we'll quickly turn to the questions that came in during the presentation. Do I need to have employees before I apply for an E-2 visa? You do not. You need to convince the government that you will have at least 3 full-time equivalent workers within 5 years of starting operations. And you'd use a business plan to show that if you don't already have those employees. And again, it does strengthen the application to have an employee before you apply, but it is not a requirement. Complicated source and trail of funds, loans and gifts, both are permissible. Loans it cannot be secured by the E-2 business or its assets. So as long as it's secured by your personal assets, that is fine. Gifts, you can receive a gift from pretty much anyone. The important thing to know is that you will have to show where the gift came from. So, you know, if your sister gave you a gift of $100,000 to put into the business, you need to show the government where she got that $100,000. Just as you would if you were personally investing the $100,000. E-2 visas can be issued for 2 investors. The requirement is that each E-2 investor must own at least 50% of the business. So if you have 2, each must own 50%. There can be substantive changes to the E-2 business after filing. Ideally, you would lay out in your initial application everything that you want the business to do so that you're allowed to do that. But if you get to the US and you want to expand the business, you do need to be careful of doing that. You probably need to at least let the consulate know that you're changing the scope of your business. Another alternative is to let USCIS know here in the US. But that is a topic that a lawyer can help you with. It is a gray area. It's not black and white. So a good lawyer can help you navigate that. And finally, Jiyae talked about this, but do be careful if you're paying a family member. The government is going to be very skeptical of whether there is a legitimate expense if you're paying your spouse for something or if you're paying a sibling for something. They're going to want to know that those funds were actually committed to the business and are not going to come back to you. All right, so lots of questions. I think we can get through a number of these pretty quickly, Jiyae. Were there any you saw that you want to dive into real quick?
Well, one question that's related to what you just shared, Dustin, is would inheriting a business from parents qualify for E-2 business? And the answer to that would be no, because you do need to show that you committed your personal funds to investing in the business. So unfortunately, that arrangement would not work.
Right, great question. So let's see, one that I saw here, can you work in the business from abroad? Immigration law doesn't really care what you're doing outside the US. So the answer is yes, you can work for the business from abroad. You know, if you have an E-2 to grow a business to employ a certain number of people within 5 years, make sure the business does that, or else you're going to have problems renewing it. But, you know, if you're able to hire people in the US and they are able to do it, and you come in occasionally to manage the business and make sure things are going well, that is okay. I've already registered my LLC, open business account, get EIN. Good. Those are all things you need to show that the business is real and operating. I'm not sure if there was a question there. I
think one of the question was, what are the processing times for Pakistan? And I do, recommend that, for specific consulate questions like those, definitely set up a consultation with us. We'll be able to look at that with you. There were some questions about immigrant intent, and I can quickly go through that. So applications for diversity lottery, 2 applications over 10 years ago, likely not going to be a huge risk for the E-2, since, it's been so long ago and it was only signing up for the lottery. Pendency of an EB3 green card case, that may be a little bit more complicated, and it really will depend on what stage your EB3 is on. If the government finds that you are likely to adjust status to a green card holder while you're in the US, that could pose a risk to your E-2 application. But this will really depend on what stage the application is on and whether the priority date is current and things like that. So definitely a more fact-specific inquiry. What
Yeah,
else
there's
do we have?
one that I just sent a typed link on, which is owning a business 50-50 with the father. It's generally fine to do an application for one investor and then later to have the second investor come in. The link that I shared, we have a blog post about whether to do an E2 investor visa or a second E2 investor visa or an E2 employee visa. And there are pros and cons to each option, but both are on the table. Your father would need to qualify as an essential worker. So learn about that option through the link I shared, and we'd be happy to talk about that more, what the qualifications for an essential worker are.
Right. To quickly go through some other ones, ongoing I-130 under the F4 category affect the E2 application. This will also depend on, the facts. If, your priority date is like 10 years later, then I think you can make a good case that you are not intending to adjust status while you're in the US. But if your priority date is like pretty much coming up, then maybe you will get a little bit more of a challenge on that regard. When you get to retirement age, can you stay if the business continues to be owned by the E2 applicant? Unfortunately, the applicant needs to continue to develop and direct the business to be able to continue maintaining status under the E2 category. So you can't, retire from the business and just be a passive owner.
Yeah, I like this question about inventory. So technically you can spend most of the investment money outside the US, but we generally recommend that you spend at least half of the investment amount in the US. So try to do that. Spend it within the US as much as possible.
All right.
And then finally, the last question we have is, if you create an LLC, you're late on filing your taxes, a couple years pass. So make sure that you're not behind on taxes. It's probably not a problem that you missed the deadline if you didn't know anything. But do make sure that if you owe something to the IRS, you've paid it. It's not a huge deal if the LLC has been dormant for some time, but if you can start a new LLC, why not start with a clean slate? That's probably what I would do. But based on the question, it sounds like the LLC has been operational for the last year, in which case it's probably not going to be a problem. As long as you're up to date on your tax payments, you'd provide an explanation about what the LLC has been doing since it was formed, and then how ideally in the last year, you've employed some people, you've generated revenues, and you're going to continue that trajectory over the next 5 years.
All
So I
right.
think that answers everything, and we are 2 minutes over. So we really are grateful to you all for putting up with us over the time limit. Jiyae, thank you for sharing your expertise, and we hope to see you all on future webinars. Reach out to us if you have any questions by scheduling a consultation. Thank you.
Thank you, everyone.